So, hi everybody, you're very welcome back to Law Hero. My name is Jen and I'm a videos about the law and other things. And today we're talking about Fe1 Contract Law. We're going to be looking at the Fe1 March 2022 paper. We're not going to go into in detail, I'm just going to show you how to navigate your way around a problem question, because in the last paper the examiner asked 8 problem questions. Now, the tone of the contract law examiner is after hardening, especially because it seems like people just still aren't getting the point she's trying to make, which is, and I quote, "A long answer and repetition of standard notes does not always equate to a good answer. Repeating long descriptions of irrelevant law or cases can show that a candidate does not understand which parts of the law are in fact relevant. Similarly, failure to apply the law coherently indicates a lack of understanding of the law," which basically means if you put down irrelevant stuff, or if you put down a lot of stuff that doesn't make sense in the context of the question, you're going to fail. And like, this is the thing I think which is really difficult for undergraduates, and especially in contract law, to understand, is that like less is more, and people are just so used to holding on to the knowledge, and they're so knowledge centric that they think that more knowledge means a higher grade, but it actually doesn't. You could know very little, apply it well, and do very well in the Fe1. A significant level of detail on cases, sometimes an unnecessary level of detail, such as the year of the cases, the exact dates and amount of money, or complex quotes from the case, but then failed entirely to apply the relevant legal principle from the case to the facts. Like, imagine if you had gone to the bother of learning off parts of the case and then it was just irrelevant. Like, what a waste of time. You might as well have been watching Netflix. The examiners have stated on numerous occasions before that candidates need to focus on the application, in italic, of the relevant law in problem questions. An answer which simply recites the law, even in detail, but fails to make any attempt to apply the law to the facts presented, will not be given a passing grade. So like, for anyone who still doesn't get it about contract law, I know lots of people have failed it multiple times. If the penny has still not dropped with you, please listen to me. I'm going to repeat this again. If you just write irrelevant, verbatim contract law notes, you will not pass the exam. You may as well not show up. Candidates are asked to write succinct answers which focus on the relevant aspects of the law and apply the legal principles to the facts at hand. And like I said with the company law that I just did, it's the same again. The examiner report is simply the recipe. It's up to you to add or take away from the recipe. It does not mean that if you learn off what the examiner said that you will pass. It's just a suggested answer. It's the bare minimum. It might not be enough to pass next time around, because if the examiner picks up that all you did was read their report, then regurgitate it next time around, they're still going to hate you and they're still not going to pass you. You are expected to advise on the law like a legal practitioner. If you don't know the answer to the question, don't answer it. Learn the law and come back next time to the Fe1. If you don't know the answer, don't write anything. Just don't, because you're going to look like a fool. And the standard is that the examiner is almost like your client. If you tell the examiner the wrong thing, in real life, you're telling the client the wrong thing. They could lose money, they could go to jail, you could ruin their life. So you might as well just get it right, or not answer at all. So it seems to me that the examiner was really kind of leaning into the whole COVID thing. COVID being a disruptive pandemic, epidemic, would usually be listed under force majeure, but there was other kind of shades of like, other kind of ways to terminate a contract, for example, like frustration, illegality and whatnot. Frustration was asked in the first question, basically somebody who had a lease, had an unprecedented outbreak of disease, which is kind of COVID-esque. So you could use frustration there. You could use force majeure there. The examiner definitely looks at, you know, termination of contracts. So as I said, the reasons for termination, like force majeure, frustration, illegality, those kind of things. The other area I think the examiner is particularly keen on is penalty clauses. They're almost asked every year. And the other one I would say, which I have noticed from this particular examiner, is their love of consumer law. Question 4. So I think that's the one we'll look at, just because it was quite a nice one. So it involved somebody setting up a dance school, and I'm not going to go down through the question, but what I would say to you is, when it comes to contract law, what you need to understand is that the common law of contract has now been basically removed when it comes to consumer contracts because of legislation, and that legislation is EU driven. So that's like the first thing you have to get into your head. Although it's a contract, the legislation trumps the common law rights. And as we know, the Sale of Goods, Supplies, Services Act 1893, that was amended by the 1980 Act, and you need to know your implied warranties under that really, really well. The other thing you need to know is that services come specifically under sections 39 and 40 of the Act, and you're allowed to bring the Act into the exam. The other thing you need to know is that, so if you're selling goods as part of a service, you will see that the examiner tries to test and see if you understand that those implied warranties of section 12 to 14 under the 1980 Act can be excluded, and they can't. For consumers, they cannot be excluded. Those implied warranties can only be excluded on a business-to-business level if it is fair and reasonable to do so. I think it's under section 55. And what is fair and reasonable is set out at the back of the Act in the schedule. So that's the Sale of Goods, Supplies, Services Act. Please note very, very well. Now, the other areas of consumer law as regards advertising, as regards the terms of the contract, which are written obviously by the seller, the contra proferentum rule applies, which means that the law is in favour of the person who didn't write it. So here it's the consumer. The examiner gave out that most people correctly knew the unfair terms regs applied, the 95 regs applied, but they made a mini essay about the regulations rather than applying them to the facts. So in this case, what could have been considered unfair would be excluding liability for personal injury even in negligence. So in contracts, even on a business to business level, you would never exclude liability for personal injury and death due to negligence, because it's just unfair. It's unfair for businesses, but it's even more unfair for consumers. The class not being refundable for any reason. So the reason why this is unfair is because that gives the seller, or the seller of the services in this case, a carte blanche to take people's money and not provide the service, which is inherently unfair. Then there's a €30 fee for late payment, which you might remember would be a penalty because it's disproportionate. If you think of any service like you've entered into, like for example a gym or like any type of service you use online, you would never see a €30 penalty. You know, it looks like a way for them to make money if somebody is late on a payment, which is unfair. But the examiner does point out that because the fee for late payment is not related to the service, as in the fee for late payment has nothing to do with the service being provided, you would be able to argue that that it's not a term of the contract, and therefore unfair terms regs don't apply. Now, the last part of the question relates to returning the ballet shoes and what's it called? Cooling off periods, usually 14 days. Distant contracts, for example, online, because here it's a website. So what happened here was a pair of ballet shoes purchased on the website were recently returned by a customer who claimed they didn't fit, even though the shoes were the size stated on the website. Happens to all of us. She said that on her website it is clear that there is a no returns unless faulty policy. You are allowed under the cancellation regs 2013 to cool off, as in a distant contract. You can return goods within the 14 days for any reason whatsoever. So number one, she's in breach of that. A lot of people thought that this was a merchantable quality issue, even though the size of the shoe is correct, it just didn't fit the consumer. Merchantable quality means that that is what is reasonably expected of a good, as in its function and purpose. So merchantable quality would not apply here. Merchantable quality would be, for example, you went to a dealership, pick up a car and the engine didn't start and it's a 222. That would be an example of merchantable quality. Finally, many candidates wasted a substantial amount of time discussing the law on incorporation of exclusion clauses in a general manner, which was not a key issue. Now, you can understand some people trying to discuss that, but I think if you are here and you realise that this is a consumer contract and that exclusion clauses only really apply in business-to-business scenarios, or for example, when you don't have a contract, like you don't have an explicit contract, like for example, those car parking cases, different because here, for example, everybody signs a document, the template she uses came from the internet, and also then she sells stuff on her website. So we're definitely in the realm of consumer law, although I can understand why people would talk about exclusion clauses. The incorporation of exclusion clauses for consumer is pretty redundant, so I do agree with the examiner. So the first one is, you know, we might still have some COVID stuff in the next paper, so just be really careful around termination of contracts. Basically, can be terminated for material breach, that is like a condition, something that goes to the heart of the agreement is broken. You become insolvent, don't carry on your trade, you're financially jeopardized, which impacts your performance, which is repudiatory breach. It means you've done something to stop your own performance. These would be the usual scenarios. As I said before, as a provider, you can argue force majeure for not carrying out your obligations under the contract. You can also argue frustration. It's quite a difficult defense for a provider to argue, but it has been successfully used in Ireland during COVID-19. I think there was one on the LEP in FBD insurance. It has been argued in that. Illegality then is when something you're doing becomes, the obligations under the agreement become illegal. And then the other one you could argue then is commercial viability. A lot of people are using that at the moment in the supply chain issues, for example, because of Brexit and because of the cost of importing goods into Ireland. It's no longer commercially viable to see the contract out, and they're trying to get out of it that way. Also, inflation would have an impact on commercial viability. So in the next, in the March 2023 exam, I would say, just given the way the world is going, you might see some supply chain-esque questions in the contract paper. You might have somebody who's not being able to deliver on their contracts because of the cost of living crisis, inflation crisis. So as I alluded to before, so incorporation of terms people can sometimes go down a rabbit hole, and I had it last week. I was giving grinds to somebody who just really didn't get Incorporation of Terms and the Battle of the Forms, and I said to her, go away and read the James Elliott construction case or the Northside construction cases. They're quite good. So I'll just give you a little bit of a rundown of the James Elliott case. So as I said again, this is supplier and buyer. So Irish Asphalt was supplying Elliott Construction for building stuff. Basically when Elliott Construction started to use the material, they started to see defects and they brought proceedings against Elliott. And the question that arose during the proceedings was whose terms and conditions the parties had contracted on. And it turned out that Irish Asphalt's terms and conditions contained an exemption clause, which we know is allowable business to business, which significantly limited its liability for any loss arising from the supply of defective material. So they obviously had a good lawyer, and what they put in was their liability was limited to the cost of replacing the defective material. So they capped their liability to remedying the defect. Irish Asphalt said that its terms and conditions, including this exemption clause, had been incorporated into the contract. So they gave actually 5 reasons. They said it was by signature. So Elliott Construction's foreman signed the delivery docket, which had the terms and conditions on the back. By actual notice, the terms and conditions were set out on their credit note. By reasonable notice, the foreman who signed had seen the terms and conditions. By a consistent course of dealing between the parties, as in there was more than one, and by reference to trade custom, terms and conditions are always on the back of the invoice. So the Supreme Court said, a contractual document, for it to be contractually binding, a document that generally contains contractual terms, or a document which a reasonable person would expect contains contractual terms, sets out the terms and conditions or refers to specific terms and conditions well known in the industry, it is not sufficient to refer to unspecified terms and conditions, nor is it sufficient to state that they are available on request. They must be timely, they must be provided before the contract is concluded. So here, the delivery docket was not a contractual document. Delivery dockets do not generally contain contractual terms. They contained only a vague reference to the terms being available on request, and they were provided after the contract was formed. It followed that the foreman's signature on delivery did not suffice. So actual notice, the court also did not agree. Reasonable notice. Notice of the side foreman was not reasonable notice here. Course of dealings, even if they were unread, terms may be incorporated into a contract by a previous consistent course of dealings, but here this was not enough to establish a course of dealings. Incorporation by reference to trade custom. This was actually discussed in the Northside case, and the court also found there was insufficient evidence of a custom well known in the quarry industry. Then the final one was reasonableness. So this is the reasonableness test around the exemption clause, which was the final defence. It is certainly true that considerations of procedural and substantive fairness and fair dealings are important factors, and the Supreme Court has overtly worked these themes into the incorporation by signature test. What is striking about the Supreme Court decision and the one in Northside is that the cases concerned business-to-business transactions that took place over significant periods of time on a reoccurring basis. The standout feature was the sweeping nature of the disclaimer of liability and the startling failure of Irish Asphalt to communicate actual notice to its customers. So that's basically the court saying that it's unreasonable to have such a blanket exemption and also not to inform their customers of it. So having a blanket exclusion of liability per se, it's fine. Like, you're grown-ups, you're negotiating a contract business to business, you both have lawyers presumably. That would usually be a heavily negotiated part of the contract, but not even communicating it to your customers, that's where they really fell down. So yeah, that's incorporation on a business to business level. As I said, I think it's called SHU, that case. When it comes to like consumer contracts and incorporation of terms, those are set out in my ebook. But yeah, I wish you best of luck in contract law.